Thank you. Please be seated. Mr. Sharp, at about 3:20 or so, just let me know how you're going. We'll make a plan.
Thank you, Commissioner.
3:20.
Yeah. So, Radis, your witness statement at paragraph 39, you make reference to in 2017, a compliance activity frequency chart was created by the Regulatory Services Division and operational from October of that year. I'm going to call that document up, but it'll only be visible to you and the commissioners because it's a potentially sensitive document. Do you have that in front of you?
I have paragraph 39.
Oh, do you have to?
No, I have.
Call up GWC.001.007.0209_E0001.
Got it.
Is this the document that you're referring to at paragraph 39 of your witness statement?
Yes.
And just before lunch, you're referring in your evidence to a process of conducting activity-based reviews.
Yes.
If I'm recalling correctly. And is this the document which you used as the basis for those reviews?
That's one document of two.
And what was the other document?
The other document is our risk category compliance activity sheet, which is used by the inspectors to enter the date, the type of audit, and the outcome of such, with a brief commentary and a risk ranking from 0 to 3. That was used in conjunction to the compliance activity frequency model.
And how did they interact? How did you use them together?
Well, when we would have our monthly meeting, we would examine what we did for the month and the outcomes of those audits, which were in that spreadsheet. And if it looked as if we'd done pit operations audits, for example, if there were areas where they were non-compliant, we would perhaps consider focusing to conduct more of those and obviously interact with the casino licensee to get them compliant. And in the other areas where they were compliant, we would look at adjusting the frequencies to say maybe we don't need to do that weekly, to perhaps doing that either fortnightly or monthly. So they were the two spreadsheets that we would examine in those monthly meetings.
And so that was developed in 2017. Has that continued to be used to the present day?
I have maintained that to date.
And does the list of audit and inspection programs in that document, which is in front of you, is that an exhaustive list of the audit and inspection programs in respect of the casino? Is that all of them?
That's all of them in respect of the casino.
And you recall before lunch, we came to this topic through discussion of regulatory risks and how does the identification of, or how did the identification of regulatory risks inform the development of this model?
That would have been through discussions in planning through the Regulatory Services Division. As I said earlier, there were 3 officers within that division that their role was to design this frequency model chart and the audit and inspection programs that went with it. And I would assume as a part of that process was assessing risk.
And
as to the controls in place.
And taking a further step back, what are the risks that are identified which are then fed into this model or lead to this model?
Well, essentially, our focus, our role was to essentially the 2 roles which I spoke of earlier was to ensure that casino gaming revenue was accurately recorded and reported for the purposes of calculating casino tax. And the other part of that was ensuring that all the processes, procedures, and the operations of casino licensee and their staff were in accordance with those rules and procedures in the operating manuals.
And I'll take you back again to your CV. We were at point 3, identify regulatory risks and develop appropriate risk treatment plans. What are risk treatment plans?
I didn't have any involvement in that for these programs.
Okay.
Yeah.
Are you able to describe what they are generally, though, even if you didn't develop
Well,
them
risk
yourself?
treatment plans would be, obviously, you could look at specific areas of risk if we're talking about casino revenue, identifying where there possibly could be risks, where there could be failures in reporting and recording. So, particularly from the table through the drop box, through count, through to cage, to make sure that all those risks were at a level that would be satisfactory. And if there were areas where we identified that risk is potentially averse, then we would look at a control to stop that.
And when you say look at control to stop that,
Well,
that's
Sorry.
how would you do that?
Well, it could be, clearly we'll communicate with the casino licensee, but it may mean suggesting amendments to the procedures or the rules or what have you that would plug that gap.
Turning then to the 5th dot point of your CV, which is now back on the monitor. You refer to consultation and liaison with WA Police, senior officers of Racing and Wagering WA, Lottery West, licensed bookmakers, liquor licensees, senior officers from Crown Casino, community gaming operators and other key stakeholders. Who were the senior officers from Crown Casino that you would consult and liaise with?
Okay. Mainly, at present, I deal with Sasha Grist, and she's in the legal services team. Prior to that, I liaised with Paul Hume and Claude Murray over matters of compliance from time to time.
And so that you say was in respect of matters of compliance.
Mm-hmm.
Can you give an example of the kinds of
Well,
matters?
if we identified an area of non-compliance and we'd ask for an explanation or a please explain, so to speak, if it was a breach of procedures, we would go through Paul and get him to report back to us. And obviously that, depending on the nature of it, it may also require us to speak to the applicable casino employee who may have been the person who breached that procedure or rule. At present, I deal mainly with Sasha Grist from Crown.
Sorry, that is Sasha.
Grist, Grist.
Thank you.
Then moving to the key achievements section, which is just below, the 3rd dot point, developed specific audit and inspection programs in relation to the regulation of the casino licensee.
Yes.
Is that what we've already been discussing, or is there any further? That's what we've been discussing. Nothing further. No.
Yes.
And if we can go to page 3. Under skills and abilities, the development of a risk-based compliance response. That's what we've already been discussing. Anything further to add around?
Nothing further to add.
Right, so I'd like to move more now to the general workings of the Inspectorate over time, and in particular since 2015. So I understand you've essentially been managing the Inspectorate since 2012. Is that correct?
Yes, that would be correct. From I need to check
Yes, you
through.
can check.
If you don't mind, just to be specific. Yes, that's correct.
So
Since I became a senior inspector from 2008, I had management over the inspectors, but I shared that management with two other senior inspectors at that time. I specialised in racing or wagering and community gaming, and then I rotated into the position of senior inspector compliance liquor. That was the period between 08 to 2012.
So in that period, did you have responsibility in respect of casinos at all?
No,
And then from 2012 to the present day, you have had responsibility for the casino inspection, managing casino inspection, is that correct?
that period, I believe, was still in relation to wagering, racing and community gaming. And
Sorry, just to be clear, you're saying the 2012 to 2015 period was still not
Yeah.
in respect of casinos, or was it in respect of casinos?
up until, well, I can't be specific about the years, but certainly at the latter end to 2015, that's when that change started, where those positions, we had a lot of restructures and rethinks during that period. So it's a little bit, I can't be certain as to the specifics during that period. It did change, but because I had a period where I was licensing and compliance as well. But certainly from 2015 marked a specific change.
And so, in particular, from the time in 2015 that you referred to in your witness statement, in paragraph 21 of your witness statement, August 2015, there's a change in the inspectorial presence at the casino. Were you managing the inspectors prior to that change in August 2015? Had you started before that?
I was always managing the inspectors, yes. So in 2015, that pivotal change, I assumed that role of managing the inspectors in solo in that position across all those industries.
I suppose my question is, prior to August 2015, did you have management responsibilities in respect of the inspectors inspecting the casino?
I don't believe so. I did, but I couldn't be specific as the dates of when that started. But it may well have been from 2014 leading into 2015.
Did you have an awareness of how the casino was being inspected in the lead up to that change in August 2015?
I had an awareness because I was with fellow managers where we discussed things. But generally I didn't have a direct role as a compliance manager for casino operations.
And until that change happened in August 2015?
Well,
Or
I can only approximate that, but yeah.
so at paragraphs 21 and 22, you refer to the change from the 20.5 hours a day inspectorial presence to about 20 to 30% of the work of inspectors being to do with the casino now. Is that, am I understanding your statement correctly?
That's correct.
And is that a decrease in the amount of time that inspectors are spending in the casino?
Yes.
And by how much? What sort of magnitude of the decrease was it?
At least prior to with the 20 hours a day, I'd say it's probably decreased. I'd say it was probably around 40 to maybe 50% prior.
And how did we might have already covered this to some extent, but how did the nature of the inspectoral role, audit and inspection, change around that time?
How did it change? Well,
In
clearly,
response to the decrease in resources, how did things change?
clearly, by pulling out of the casino, having that presence there was quite a fundamental change to how we conducted our compliance activities out there. It was quite a gigantic change as far as WA casino regulatory work. And that meant that at that time, with the inspectors, with the various inspection and audit programs that we have, that not just in relation to casino, but also in relation to the other industry you regulate, it was trying to get that balancing act of still having effective coverage out there by attending the casino to perform the audits and inspections that I had allocated to be done. So that required a lot of change and adjusting to have to get those tasks done in order to meet our approved key performance indicators.
And in your view, has the removal of the dedicated inspectorial presence in 2015, has that detrimentally affected the ability to regulate the casino?
In my opinion, yes.
And in your opinion, would it be a more effective regime of oversight if the permanent inspectorial presence was reinstated?
Yes.
At paragraph 23 of your witness statement, you referred to from approximately January 2015 that you'd made specific roster shift amendments to require inspectors to perform a shift of 9.5 hours at the casino. What was the purpose of making that change?
Okay. As I said in my statement, resource permitting, that I wanted to have coverage out there. And there were two main reasons that I wanted to do that. Firstly, every month I allocate the audits and inspections via the frequency chart. And obviously I also allocate liquor inspections and racing inspections and so on. And it was the inspector's responsibility to then, manage their time to go out there and do the casino audits. And at the end of the month, when I would go to report to the Commission and collect my statistics of what we'd achieved for the month, I could see that it was getting hard to achieve those targets. And for that reason, I then decided that I'd rather roster the inspector out there, so when they were out there, they did the job that I allocated to them. The second part of why I did that was I just wanted to have a little bit more of a visible presence out there.
And you have attached your roster document to the witness statement. So can we call up DLG.001.006.003? Are you able to just talk me through how this roster can be interpreted?
I can. Well, there's two vacant lines, as you can see. Well, if you look at the legend in the codes, a day shift commences at 07:30 and finishes at 17:30. The L represents what we call a lotto shift, because we are contracted by Lot US to do a nightly audit. That's from 10:30 to 20:30. An M shift is 12 midday to 10 p.m. or 2200. An A shift is from 1400 to 2400. And an A1 is 1600 to 0200. If we refer to the roster and we look at the shifts that are coloured in green, green indicates your shift is at the casino.
And so when you're talking about a shift being a 9.5 hour shift, is that, what time of the day would that 9.5 half-hour shift be?
Okay, well, if you look at the 30th of April, the D, which is in green, is from 07:30 to 17:30. If it was an M in green, that would be from 12 midday to 10 p.m.
So it
And the
varies.
same would go for an A. So when the inspector looks at the roster and if he sees it's highlighted in green, then that means he would conduct his shift out there at the times that are specified in the legend.
So what is A again?
An afternoon shift, which is from 2 p.m. to midnight.
So for those shifts, would the inspectors report to the departmental officers and then go to the casino, or they go directly to the casino?
They go directly to the casino. They start and finish their shift there.
And what resources are available to the inspectors at the casino?
We have an office there that is specifically for our use, and access is only for inspectors.
And what does the office contain?
General office stationery, office department computers, and access to the cameras, Crown surveillance cameras.
And in practical terms, do the inspectors stay in the office, or do they go outside of the office, or how do they conduct their duties?
Well, most of the audit inspection programs, preferably you go out and on the floors, but it also means that you may have to go out to certain offices within Crown, particularly if it's an audit that in relation to, revenue, and you meet particular casino staff to obtain information for your audit, your inspection, and some of the inspections can also require you to use the camera equipment, the CCTV surveillance to examine gaming activities.
Commissioner, I attended DLG 0001, 0006, 0003, which is the inspectors roster from 30 April 21 to 13 May 21.
That document is tendered, and did you tender the Excel spreadsheet?
My understanding is it's already been tendered.
Do you intend to move away from this document, Mr. Sharp?
I was going to, so
Could I ask a couple of questions about it? So why would you have 5 inspectors rostered at the casino on one day? And I see that that's also an EGM day.
That's right. That was a day that the casino was closed due to COVID, and that was a good opportunity for me to have a group of inspectors perform audits and inspections on electronic gaming machines on that day. It's a rare and unique opportunity to perform a lot of work whilst the casino is actually closed. It allows us that ability to go and do a fair amount of work in a day. And that was just before reopening.
So on a week where the casino was operating, how many days of that week would you have an inspector at the casino for a day shift?
I would try, resource permitting, and depended on what our priorities were, I would try to at least have 9.5 hour coverage per day, one inspector.
So that could be at any time in the 20-hour period, or?
That's right. It could be a day shift, an M shift, or an A shift, or even an A1 shift.
And of that 9.5 hours, you may not be able to answer this question, but in that 9.5 hours, how many hours or minutes would an inspector simply be looking at the cameras, for example, monitoring activity just generally?
They could spend, it depends on the type of audit inspection that they're allocated. It could spend up to 30 to an hour to over perhaps. It depends.
30 to an hour, so 30
30,
minutes to
half an hour to an hour, depending on the audit or inspection program they were looking at. They had the ability to go out on the main gaming floor or any gaming floor and visibly watch casino gaming activities. So, and some of our audit inspection programs weren't in relation to gaming activity, which would require us to look at, CCTV coverage. That might be an audit that's based around casino gaming revenue. So there wouldn't be a need to look at camera coverage.
We've heard from another witness that inspectors weren't encouraged to go into the international gaming rooms because the presence of a government inspector was not appreciated. Do you know anything about that or not?
No, I can't really comment about that. I don't. There was talk about, I guess, that having the government inspector, perhaps, in a private salon, wouldn't go down well with the casino licensee. But I've never heard that officially.
But on the other hand, there's no particular direction to inspectors to make sure that they do go into those rooms regularly.
There was no direction.
Thank you, Mr. Sharp.
Turn then to a letter that you wrote, Mr. Addis. I'll call up GWC 0001, 0003, 0005. This is a letter dated the 1st of February 2018 from Mr. Radis in the capacity of Acting Director, Industry, Regulation and Education for Racing, Gaming and Liquor, to Mr. Preston, Executive General Manager, Legal and Corporate Services, Crown Perth. And in particular, can we pop out the third paragraph, please? So I was just going to ask you about why you've written this letter and why you've made this request.
Okay. Again, when I explained previously about I made that decision to roster an inspector at the casino. Following from that, what Crown's process is in regards to meeting the directions is that Crown would provide us every morning with what's called the daily surveillance reports, and that's by email, and that's an actual physical report that surveillance prepare, Crown, and it records and identifies any activities that happen for that particular trading day, any matters of non-compliance or that were noted by surveillance or security, any suspected illegal activities. So that would be reviewed the following day. And when I increased the frequency of inspectors being out there, I saw fit that it was important, as I said before, to have a presence out there. I wanted casino staff or employees to know that a government inspector was back out on the floor. Following from that, the letter I wrote was purely because when we would read in the surveillance reports the next day of a matter such as a cheating offence that had occurred on a table, or a person who was barred from entering the casino under the Casino Control Act had entered whilst barred, they're matters of which inspectors are authorised and empowered to deal with at the time. And what was happening was, prior to the inspectors being sort of reinserted out there with those shifts, I had an inspector there for one day, and the next day you'd read in the surveillance report that there was a cheating matter. And all that time I had an inspector that was in the office doing an audit or in the offices of Crown, and it just seemed silly to me to not deal with it then and there. So I decided that I would instigate that, and what that means is when an inspector commences their shift, they email both security and surveillance, and they advise them that they are on shift from a start and finish time, and they are to contact them on their government mobile phone of any of the activities that I've suggested in the letter. So that way, if a cheating matter occurs, or collusion, or a barred person, for example, the inspector can be called upon and can deal with it promptly, and that could be by way of a caution or an infringement notice if that's the case.
Commissioner, I tend to GWC 001, 003, 005, being the letter from Mr. Radis to Mr. Preston dated the 1st of February 2018.
That document's admitted as an exhibit.
Turning then to paragraphs 49 to 51 of your witness statement, Mr. Addis, you refer to a change in tax auditing software, and in summary, you refer to the RG system, which was in place up until 2015, and that was retired in 2015, and a new software program titled Navigate was used. Why was the change from the RG system to the Navigate system implemented in 2015?
I wasn't part of that process. That was at director and corp exec level, but my limited understanding was that they wanted to have a unified system. And then prior to that, we had the RG system, another system called LLS, which dealt with liquor. So we had different systems. So the decision was made for various reasons that we needed a unified system that would be a one-stop shop for all our industries.
And at paragraph 51, you make the comment that Navigate, the new system, Navigate, was not designed to independently calculate payable casino taxes. Do you consider that that's a deficiency in Navigate as compared to the RG system?
Yes, I do.
And how would you see that that could be remedied, that deficiency?
Design a system to do exactly what it used to do, the previous one.
In your witness statement at paragraph 24, you refer to the report of the Victorian Auditor General titled Regulating Gambling and Liquor, which was published in February 2017. I'll call up that document, call it PUB 0004 008 001. Is this the report you're referring to?
Yes.
Why do you refer to the report in your witness statement?
Because I think there were some similarities there in how VCGLR operated their casino regulatory regime and as to WA. So
perhaps if we can go to page 13. There's a section titled Compliance, and under Compliance, the second paragraph there, can we pop that out? I'll just let you read that, Mr. Radis. Perhaps in fairness, I should ask you, have you had the opportunity to read this report before?
back then,
Back then?
yes.
But no. The question I have really is just a reflection upon this observation and whether you consider that the Western Australian system is sufficiently risk-based.
I do believe that there was definitely some sufficiencies there. However, there was always certainly room for improvement, and clearly there is. So at that time, in assessing it, it was also, I think, and I could be wrong, that at that time VCGLR also pulled out of having an inspectorial presence. I could be wrong, but that was a major focus or highlight for me.
Yes, well, perhaps we can. So sorry, just so I'm clear, did you consider at the time when you reflected on it, that the Western Australian system could be more risk-based?
Well, there was always potential for it to be, yes, more than it was.
And did you take steps to make it a more risk-based system?
Well, as I said, it just so happened that I'd made some of those changes to the team and our presence out there, and it just so happened to coincide with that VCGLR report, roughly. So, because talking to inspectors and team meetings and that, obviously, you know, that because it was such a major shift to pull out of the casino, you know, required a lot of rethinking about how we can regulate it effectively. So that was why I made some of those changes. But clearly, whilst the regulatory service team, the work that was done to, I guess, have a fresh start at all the new audit and inspection programs, I think in general they're actually quite robust and good. The audit and inspection programs themselves, and particularly the monthly meetings with the appropriate directors to examine those outcomes and then make assessments on risk, I think was a good model. Obviously, you know, there's always room for improvement and change, and clearly I'm here today because there were certain audit inspection programs that we didn't do.
But did you generally see that this report and its observations were consistent with the changes that you'd been making, or did you see them as contrary to the changes you've been making?
I think there were some consistencies there, but yeah.
I will just take you to the bottom of the page under casino supervision. So just, if you can pop out those last two paragraphs, I think this might be what you're referring to, Mr. Addis. I'd like to have a read of those.
Yes.
That's what you're referring to? Just
Yes.
What's your awareness of whether there is a dedicated casino team in Victoria now? Are you aware of what's happened there? Now, in that paragraph, there's a reference to money laundering. Did you understand that the casino inspector's role in Western Australia was to investigate whether money laundering was occurring at the casino?
We did not have a role in regards to auditing or inspections or compliance in relation to anti-money laundering or counter-terrorism funding.
And was there any direction to casino inspectors about what they should do if they came across evidence of money laundering?
If an inspector had happened to come across those types of matters, they would have reported it to me and I would have reported it to my director, and ultimately they would be reported to the Gaming and Wagering Commission.
And were there any instances of that kind that you did report? not
Not that I'm aware of.
And did the department or the Gaming and Wagering Commission have any specific policies or procedures relating to risks associated with money laundering?
No, that I'm aware of.
We then go to page 15 of the Victorian report. If you go to point 5, can you pop out point 5, please? Is this something, so this recommendation is to develop principles or guidance for assessing net detriment and report transparently against them in decisions on applications for electronic gaming machines. Are you aware of whether this assessment occurs in Western Australia?
Well, there is a process involvement in regards to the approval of electronic gaming machines. As I said earlier, any application for a new game has to be tested and assessed by an accredited tested facility, and that's in accordance with the Australian National Standards and the WA Appendix of the National Standards. And obviously there's other... I specifically don't deal with the process of approving or seeking approval for gaming machines, but there is a process in place, and that's obviously reliant on the ATF providing reports to say that it does meet the standards as set out by the national standards, and particularly the WA Appendix.
So who's the ATF?
Accredited testing facility that specialise in casino gaming, IT and equipment.
We then go to page 16. Yes, and point 14. We recommend that the Department of Justice and Regulation develop performance measures to enable regular monitoring and reporting on the impact of liquor and gambling strategies and initiatives. Is that monitoring and reporting on the impact of gambling strategies and initiatives something that occurs in Western Australia?
Not that I'm so much a part of. No. As I said before, we report internally monthly, but that's ceased. It's only recommenced, and it's ceased for some time. But most of the reporting that I do is to my director. And if we're talking gaming activities or casino-based, if there's a need, then that monitoring and reporting is through to the Commission. I'll go back a step. We report to the Commission every month on our targets, our KPIs that we achieve for that month, as well as Crown provide statistics on their internal monitoring of casino gaming activities, and that gets reported to the Commission every month as well.
Commissioner, I tender the Victorian Auditor General's report with identifier PUB 0004 0008 0001.
That document is admitted as an exhibit.
Turning then to another general topic, what do you consider would be the resourcing required to provide adequate supervision or regulation of the casino operations?
Okay, I would, in my opinion, there still needs to have a presence of a government inspector on shift, and certainly perhaps an auditor who could be suitably qualified to do forensic type of financial accounting audit. That could be a day shift role, and then various levels of management, and obviously the Chief Casino Officer overseeing.
And do you consider that the current system of having one shift there is adequate, or if the resources were available, would it be preferable to go back to having the two-shift system?
As a minimum, yes, to go back to a two-shift system, but
As a minimum?
yeah, to have what it was previously for the 20, that would be a minimum, but I certainly would recommend that that should increase.
So that would be a minimum, but what would be the desirable position?
Well, you have more officers on duty during the day doing more work around casino regulation. And as far as shift workers go, you might just have one or two perhaps on a night shift. And they could focus on gaming activities, the conduct of the games, the rules, are they being applied, the applicable casino staff on the gaming floors are performing their roles in accordance with the procedures and the rules. Yeah, certainly an increase.
And so to achieve that, would there need to be an increase in the number of inspectors engaged by the department?
Yes.
And of what order?
You could at least have up to 6 government inspectors, for argument's sake, 2 forensic auditors, a supervisor, a manager, or a director, and they could report arguably directly to the Gaming and Wagering Commission, for starters.
Just one final point. At paragraph 12, regarding training, of your witness statement, paragraph 12 of your witness statement, you say that the casino licensee has made available their gaming equipment facilities in its croupier training school for our inspectors to have refresher training of the authorised table games which are played at the casino. And then you say that these training sessions are not conducted by Crown personnel. So who does conduct them?
We do it ourselves.
Sorry, where are we, Mr. Sharp?
Sorry. This is paragraph 12. Paragraph 12 refers to facilities, yes. Turning then to the topic of electronic gaming machines, in the risk assessments that have been performed, have you identified the social harm associated with electronic gaming machines as a regulatory risk?
That would be a question best answered by the regulatory services team in regards to harm minimisation principles.
So the work that your team does is not directed to addressing the social harms associated with electronic gaming?
Not specifically, no.
And are you aware of whether the regulatory services team has developed a treatment plan in respect of electronic gaming machines and their social harms?
I'm not aware of one.
So then I'll just turn to the regulatory framework around electronic gaming machines.
Yes.
So I'm not sure if you're aware of the evidence that was given by Mr. Toyne, but Mr. Toyne gave evidence that the regulatory control the department has, or the Commission has had over the activities of the casino has lessened over time. And he gave evidence that in 1985, it was government inspectors who would seal the CPU board within an electronic gaming machine, and it was only a government inspector who could break the seal. And he gave evidence that the sealing of the CPU was subsequently handed over to the casino as a matter for their responsibility. Are you aware of when that shift in responsibility occurred?
I can't exactly remember when that occurred, but it did occur. And that may well have been at the time that I was a shift inspector, but I can't be certain.
So that would make it in the early 2000s?
Up to 2008.
And in the time prior to the removal of a dedicated casino inspectors in 2015, what was the inspectional audit regime around electronic gaming machines at that time?
I couldn't tell you because I wasn't responsible for casino regulation then. As I said previously, I was more involved in wagering and community gaming and liquor activities, so I can't say for certain.
No. Okay. And what's the current inspectional audit approach in respect of electronic gaming machines?
Well, we have several programs, audit inspection programs around electronic gaming machines, and as I said earlier, there were specific tests in regards to the integrity of that machine. And we also check that the rules are displayed on the machines and the serial numbers, the plates. As I explained earlier, the HMAC SHA-1 signatures are there, and they verify the machine as approved. And the return to player, the theoretical return to player. We also have an EGM revenue audit as well, and that's conducted quarterly.
I just wanted to look at one particular review of electronic gaming machines. So just call up GWC.002.0016.0061. So this is an agenda paper from 2012, so I appreciate it's some time ago. But if we can just scroll a couple of pages. I'm just wanting to get to the end of the document so that you can see that you've seen this before. So stop there. So this is when you were the acting director of compliance. You supported the recommendations. So I just want to go back to page 47, please. Now you've referred earlier to the 90% standard. Can we scroll up, please, just to show some more of the background? You've referred to the 90% standard, and you've referred to, sorry, that's what you've referred to. So you can see at the foot of the page here that the Commission in November 2011 has resolved to require a 90% return to player from an electronic game. It refers to on at least one occasion during the previous 4 full reporting periods. Are you familiar, and do you remember this?
I do.
To some degree, yes?
To some degree, yes.
So in this document, if we can go to the next page, there's a, sorry, at the top of the, that's what I was looking for, the top of the page, it says at the February 2012 meeting, the Commission adopted its EGM return to player policy that gives effect to games being required to achieve an return to player of 90% over a period of 24 months.
Yes.
See that? And where a game fails to achieve a return to player, it's to be resubmitted to the accredited testing facility to confirm the accuracy of the theoretical return to player.
Mm-hmm.
So note that in this reporting period, if we scroll down, sorry, next page, there's discussion of 2 games. Sorry, can we go to the page, the last page of the document again? Page. So okay, Crazy Balls and Sheriff's Bounty. If we go back to the page we were on, please. So if you could just read through the descriptions for item 1 and item 3, and I'll just ask you some questions.
Yes.
So ultimately, if we then go to the end of that document, so it said that with the exception of 2 games, all games meet the criteria outlined in the Commission's policy, and it's recommended those 2 games that fail to meet the criteria be exempted from the need to be reaccredited. What was the reason for not requiring reaccreditation of those games which hadn't met the criteria?
Well, I'll just preface by saying I'm not an expert in electronic gaming machines. They're very complex machines that are very complex algorithms. From my understanding, it's a theoretical return to player, which is set at 90%, so in theory, and that's over the life cycle of that machine. And that obviously depends on how many times that machine is actually played in order for it to reach that full cycle. So I think just briefly reading that and trying to recollect, those 2 machines weren't played very often, which may be part of the reason as to why, if you balance it over, whether it was 12 months or 24 months, it may not have reached that 90%, potentially based on the fact that it wasn't played often enough. I'm not an expert on giving an analysis on the inner workings of the software of electronic gaming machines. I guess that was hence why there's a very heavy reliance on ATFs to provide comfort to the Commission that they should be approved to be played.
Could I just ask a follow-up question? If we could go back to the previous page with that, would have the table. It looks to me as if, as a matter of the rules, 90% means 90%. That 89.96%, if you were looking at it in terms of materiality, would usually be regarded as, if you're thinking of audit and the concept of materiality in audit, that 89.96 would be regarded as close enough, or the variance immaterial. But it looks to me as if the approach was 90% means 90%. Is that right?
In theory, 90%. It was a theoretical return to play of 90%.
All right. And by theoretical, it has the meaning that you described earlier, which is you're looking at the lifetime of the machine.
The life cycle of a machine.
Okay. Thank you.
Yeah.
Can the one I'm going to now be shown? It can be shown. Okay. Going to turn to another. I should. Can I tend to that? Let me tend it already. Can we call up GWC 0001 0013 0026? So we're at page 6. This is part of the casino manual as at 23 February 2021. Are you familiar with the casino manual?
Yes.
We can go to paragraph 1.5. Do you see that? Yeah, sure. Can we pop out 1.5, please? Are you aware of when that requirement was introduced into the casino manual?
I can't remember to be exact when, but I am aware of it.
Mm. And do you know if this requirement to maintain an anti-money laundering, counter-terrorism financing program has been audited by the department?
Sorry, can you say that again?
Has the department audited whether this requirement to maintain a program has occurred.
No. May I
Yes,
just
go
add
ahead. Go
that
ahead.
we are doing that at the moment, so we're obviously in review, working towards an appropriate audit or inspection program in relation to 1.5.
And can we then call up? So the next document I'm calling up is a sensitive document, so it won't be shown on the public screens. So we call up GWC 0001 0013 0027 underscore 0006. You have that? No? Do you see that now?
You can make it a bit larger.
Can we enlarge it? And the paragraph is paragraph 2.1.
Yes,
Yeah.
thank you.
And that provides for the operator to detect and report suspicious transactions.
Yes?
And do you know if that requirement was ever audited by the department?
No, not that I'm aware of.
And if it had happened, then across the last 6 years, then you would be aware of it?
I would be.
Right. We'll then turn back to, sorry, one moment. Is the next one public or not? Yeah, I'm going to do 6 page 11. Public. Publicly? Yeah. The next document can be seen publicly. We'll get back to GWC 0001 0013 0026, but this time at page 11, please. Can we pop out 4.2 and what's below it? Just give you a moment to read that, Mr. Addis.
Yes.
So this procedure effectively creates a procedure, what's set out there is a procedure for a patron to buy back the foreign currency that they brought into the casino for the purpose of gaming.
Mm-hmm.
And did it occur to you that this opportunity might create a risk for money laundering to take place?
It didn't occur to me, no.
And does it occur to you now?
Potentially, yes.
And has there been a risk-based compliance response to that risk?
Not at present. There is no foreign currency program, I believe, at the moment at Crown. Yeah.
Sorry, I missed that.
I don't believe there's any foreign currency program in place now at Crown at present.
And
Well, there's no international gaming at the moment.
oh, I see. Mm. And just while we're on the casino manual, in paragraph 44 of your witness statement, you talk about compliance-related issues that the GW Commission may be required to consider as being broad and varied. And one of the things you refer to is considering and approving amendments to the rules of an authorised table game and to the authorised casino manuals. Is it your understanding that only the GWC would amend the casino manuals?
It's my understanding, but I do believe there's some delegated functions of the Chief Casino Officer I believe, but I can't be specific as to exactly what. But in general, the Commission do those approvals.
And turning then to paragraph 45 of your witness statement, you state that every agenda paper is finally examined by the Deputy Director General or Casino Control Officer prior to forwarding them.
Yeah.
Sorry. Should that say prior to them being provided to the Commission members?
Yes.
And so that's your understanding of the practice, is that all of the submissions will then go through the Deputy Director General or the Casino Control Officer. Is that how the system operates?
That was, yes.
And is it still now how it operates?
Well, at the moment it goes through, it was going through the Director of Strategic Regulation whilst he was Chief Casino Officer in that interim period.
I see.
At present. So to keep it simple, I would draft a paper for the Commission, and it could be on a various matter, and I'll report that to my Director, and should he agree with the recommendations or the paper, we countersign that, as I stated in my statement, and that would be referred to the Executive Officer of the Commission, who would collate all those agenda papers, and they could come from licensing, from strategic regulation, from various operational divisions, and they would be collated, and then before they're forwarded to the Commission members themselves, they would go to the Deputy Director General, or up until now the Director of Regulatory Services, for vetting and checking before it finally goes through to the members.
Just refer to the Executive Officer. So what's the Executive Officer's responsibility? The Executive Officer is different from the Chief Casino Officer?
Yeah, the Executive Officer, forgive me if I got a title wrong, but she is the person that is the organiser of the meeting and collates all the information and distributes it to the members and does the minutes and the agendas and all that. So it's their role to collate all that information and get it ready and prepared, and then would prepare it to the DDG, the Deputy Director General, and then that would come back, and then she would distribute it to the members in the format that they're used to.
We'll change topics again and turn to the topic of conflicts of interest. The department has a code of conduct which I'll now call up. So that's GWC 0001 0011 0001. Can we please turn to page 2? So this sets out the purpose of the Code of Conduct. And I note that paragraph 4, can we pop out paragraph 4?
Okay. Yes.
So it encourages anyone with questions about the Code of Conduct to discuss the Code of Conduct with their line manager.
Mm-hmm.
So I take it in respect of inspectors that they would be discussing it with you, is that correct?
That is correct.
And do you have regular discussions with your inspectors about the Code of Conduct?
I can say that we have had many discussions of late in regards to conflicts of interests. But prior to that, I certainly was aware, as was the department, of, at that point, conflicts of interest within the Inspectorate of the inspectors that I manage.
And what was the extent of the, sort of education or information provided about conflicts of interest?
I would say it wasn't that high, but it certainly was first and foremost aware as an authorised officer of whether it was the Liquor Control Act or the Gaming and Wagering Commission Act, that as authorised officers their responsibility to understand that the position and title that they held was important, particularly from the aspects of integrity. The inspectors abroad have a wide range of functions. They'll deal with racing, gaming and liquor industries, which are always interesting industries to regulate. So it's important that they needed to maintain that integrity, that if there was any areas of concern that they had in regards to conflicts of interest, they'll raise it. It's certainly come to light more recently. Yeah.
And so if we can then go to page 3, so under the Code of Conduct Principles heading, we can see it says the Code of Conduct defines the following 7 principles to govern our conduct, and the 6th one being conflicts of interest, gifts and benefits.
Yes.
And then if you go to page 9, so this is the statement about conflicts, which is set out in respect of that principle. Do you see that?
If you could just make it.
Yeah, can we enlarge it a little?
Thank you.
And in the second paragraph, it identifies the kinds of conflicts that can arise. The concern is a conflict between the performance of public duty and private or personal interests, and that conflicts may involve personal, financial or political interests and may be actual, perceived or potential. See that?
Yep.
Is that document being intended? Oh, it's got it. Finished now. Tender the Code of Conduct, the Department of Government, Sport and Cultural Industries, GWC 0001 0011 0001.
That document is submitted as an exhibit.
I call up DLG 0002 004 0056. So this is a conflict of interest form that you've submitted.
Again,
Again? When did you first submit it?
many years ago.
And when you submitted it the first time, did you address both of the issues that are addressed in this document?
The second one was only just, well, actually, if we go to the other page.
Can you go to the second page, please, or show both pages at the same time? So the first one relates to you being in a band that performs sometimes at licensed venues.
Yes, I do.
And the second concerns a relationship to the holder of a current producer's liquor license.
That's correct. Yes.
And which one are you saying is the more recent?
I was just trying to find the date.
So this is the 10th of
yeah,
March
yeah,
2021,
yeah.
so this is just
Yeah.
the last couple of months.
What's the third page, may I ask?
Yeah, well, can we have the third page? I'm not sure if there is.
Okay.
So then just go back to showing the first 2 pages again.
I say that because when I updated, I actually updated the fact that I'm a team manager in a sporting club that holds a liquor licence, and I did refer to it. So I'm scratching my head a little bit about that not being in there.
So there's another conflict which
Well-
you've declared, but it's not appearing in this document.
I need to double check, but I certainly did declare that. So my interest in a sporting club that does hold a liquor licence. The conflicts of interest that were the perceived conflicts that are placed are in relation to liquor only.
In relation to liquor, yes.
Yeah.
And so perhaps just starting with the one which you've just mentioned. So what's the conflict that you've said you've disclosed but is not in this
I
document?
was trying to think. Yeah, I did definitely disclose it, but I'm a team manager in a football club that holds a liquor licence, so I declared that
And how do
only
you
fairly recently. So
manage that conflict?
how do I manage that? Well, I don't conduct any inspections there, and if any inspections to be done, they're to be allocated by the director or not I.
And turning to the two that are listed here,
Mm-hmm.
the second one you referred to having a family relation to the holder of a current producer's licence,
Yes.
and you've set out on the next page, understand how you manage that conflict. So can you explain how you manage that conflict?
As the same as I said before with the club, any audits or inspections to be undertaken aren't to be allocated by myself, by me, and I won't have any role in regards to the regulation of that particular liquor licence.
In respect of the football club, I understand from what you're saying you're a manager of the club, but not the bar.
Not at all, sorry.
So can I just...
I'm, my son plays for the under-18s and I'm the team manager.
Right.
There's absolutely no role that I have with the club in the form of the committee or anything in relation to bar or liquor sales. It's just purely the team. Sorry.
No, it's probably my misunderstanding. Thank you, Mr. Shaw.
And in respect of the first conflict, I noticed that you said that there's nil matters that are taken to address the conflict or perceived conflict. Okay. So how do you so why have you declared a conflict but then said no action is necessary to manage that conflict?
I thought I addressed it in two, but when I said earlier that there were discussions that I had with my director at the time when I'd lodged this, that was what my intention was, that I wasn't to have any role or influence in relation to, allocating audits or inspections of the licensed premises.
No, sorry, I think I'm just going back to what you've addressed as number one.
Yeah,
the first
I don't know why I put nil, to be honest, if that's what you're asking.
Well, I suppose what I was trying to understand is how you've gone about the process of assessing how to manage the conflict or whether action is required to manage the conflict. And I note that you go into some detail about the conflict. For example, you say that you use the services of a booking agent. So I was wondering, why have you identified that you use the services of a booking agent?
I don't. And what I've done in that regard, if we're looking at point one, is that I'm a musician and I don't have any role to play in regards to booking, and I left that role to other members of the band to take care of that. So I've completely divorced myself from any of those arrangements. Whether I've detailed that, I obviously didn't enough, but that was how I manage it, and that was the decision that I made, and I've always stuck by that in all the years that I've been a musician.
And in that, you also refer to the band. you say that you don't get personally remunerated for the performances, and is there a remuneration for the band? Or?
When you play original music, you do it for love. No one comes to your gigs, particularly when you're pushing 50. It's hard to get people to come watch you perform, so it's for love. So I'm probably being a bit cheeky by saying remunerated. So I certainly don't. I do it for love.
Does the licensee stand you a free drink during the course of the
Water.
day?
Commissioner, you asked me to give you a time check at about this point.
I did.
I think probably 20 minutes.
Does anyone think they're going to be a long time? No? I'll take that as a no from everybody. Well, we do need to finish today. Mr. Radis, would you like us to take a 5-minute break, or are you happy to continue on?
Either way, I'm happy. I'm happy to continue on if you want to have a break.
Well, let's see how we go. But if you wish for a break, just let me know.
Thank you. Okay.
Commissioner, I tender DLG 0002 0004 0056, the declaration of a conflict of interest by Mr. Radis dated the 20th of March 2021.
That document is admitted as an exhibit.
And while I'm tendering documents, there was a document I referred to earlier. I wasn't sure if it had been tendered already, but it hasn't been tendered. So I also tender GWC 0002 0016 0061.
What was that? Just remind me what that was. It was the return to players from the EGM. So
Yes, at pages 47 to 64.
yes, that document is admitted as an exhibit.
Call up DLG 0002 0004 0045. So this is a chain of emails commencing with an email from a particular inspector dated the 26th of February 2021, and the emails continue through the 2nd of March 2021, and they're between Mr. Radis and various others. Can we go to the last email at the bottom of the chain? I'll just give you a moment to read this, Mr. Radis.
Yes.
So this is an inspector declaring that the inspector's son is a licensed employee of Crown Casino. Do you agree with that?
I agree.
And if we then go to an email from Mr. Radis dated the 2nd of March 2021 at 11:34 a.m. So can you just show that that's, oh, it does show it's from Mr. Addis. Can you scroll down a little just to show what's above it? we show the date stamp, please? There we go. So in the first paragraph, you note that the conflict was declared when the inspector first joined the department.
Yes.
And at the time when that declaration was made, when the inspector first joined the department, I should first add, when did the inspector first join the department?
I couldn't tell you exactly, but it's probably over 10 years.
And are you aware of what process happened following the declaration when the inspector joined the department?
I'm not aware. I wasn't a part of that recruitment process, so there were others that were a part of that process when he was employed. But I do believe in conversations with the inspector, he declared that even at interview. And I'm just not aware of that process. But he certainly did declare it before he commenced with us.
And so when you say, as you are aware, are you directing that to the 3 recipients of the email or only 2?
Where are we?
Who do you say would be aware that it was declared initially?
Where am I saying that?
So sorry, just in that
Email?
first paragraph, the last sentence of the first paragraph, you say, as you're aware, the inspector declared it when he first joined the department.
Yes.
Who are you saying was aware? All 3 of the recipients of the email?
All 3, because
and why? Oh, sorry.
Sorry.
Why do you say Why do you say that they're aware of it?
Because at that stage, at that particular point in time, those particular officers were in HR, so they were aware that it was. I guess the problems is that the mitigation strategies weren't outlined as they are now. So whilst they were aware that there was a conflict of interest, perceived or otherwise, there wasn't a mitigation strategy in place. And around this time, that's when that mitigation strategy was implemented. So I did address it to all 3 in the knowledge that they were aware that he did declare at the time.
So just so I understand, I'm not sure I understand properly, is your evidence that the conflict was declared, but at that time there wasn't any mitigation strategy or any management strategy that was in place? And is that your evidence?
That's correct.
And is that the case, to your knowledge, generally, that there hasn't been management of conflicts, that they've been declared but not managed? Is that right?
Yeah, yes, from my perspective, even prior to my time, there are other examples of inspectors who had partners or family, friends that were employed at the casino. And I wasn't aware of any mitigation strategy. I certainly didn't receive any instruction or direction that, in this case, here's the strategy on how we manage that.
Did it cause you concern that there wasn't mitigation strategies in place for declared conflicts?
If I'm talking about this specific case, no, I didn't. I didn't have any reason to doubt that person's integrity, but clearly it's the perception to the public and other matters where it needs to come into light. And obviously we have, and we've since dealt with it.
And so what is if I understand what you're saying correctly, there's now mitigation strategies that are being put in place, is that correct?
That's correct.
And what are those mitigation strategies?
Well, if we're talking about this particular person, he has no role, no regulatory role in regards to casino activities.
And more broadly, not just limited to this person, but more broadly, what is the approach the department's now taking to managing conflicts of interest?
Well, once they're declared, I report them to the director, and the director then reports, I believe, to the Deputy Director General and the Director of HR, Human Resources, and I would imagine that there's discussions at that level in regards to what strategies should be put in place. And then once they're agreed, they're implemented.
And so for about how long has that process been in place?
Fairly recently,
When you say
months.
months?
If I could just preface also that I think that through, certainly if we are referring to matters such as conflict of interest at the casino, up till recently anyway, the Gaming and Wagering Commission considered conflict of interest only just yesterday.
Yes, well, and that's
On Tuesday, I should say.
when conflicts of this kind were declared to the department, was there any communication of that declaration of a conflict onto the Gaming and Wagering Commission?
Not that I can recall previously, no.
And is there now a process for declarations of conflicts by departmental officers to be notified to the Gaming and Wagering
Yes.
Commission?
Yes. Yes, there is, thank you. Only just recently, yes.
Commissioner, I attend a DLG 0002 004 0045, which is a chain of emails commencing with an email from a particular inspector dated 26th of February 2021 to 2 March 2021.
Those documents are admitted as into into evidence as an exhibit.
Turning then to another topic, in 2010 there was a repeal of part of the casino control regulations which concerned junkets. Are you aware of that repeal?
I am.
And were you involved in any discussions leading up to that repeal?
No.
We call up GWC 0002 0016 0001 _17. This is an agenda paper dated the 5th of February 2010, so going back some time. And at that time, your substantive role was the Senior Inspector Compliance, but you were acting as a Deputy Director of Licensing.
Mm-hmm.
Can we go to the next page, page 18? You signed that. It's been initialed by someone else. Do you recognise who those initials would be? Or who would you think would have been the person to sign off on that paper at the time?
I can't be certain, but that could be Mick Connolly's initials.
And then if we go to the next page, there's so this is an attachment to the paper that you've authored, and it's from Nick Toyne, and he's identified as the Acting Deputy Director Licensing as at 6 November 2009.
Mm-hmm.
And were there more than one? Was there only one, or were there more than one deputy directors of licensing?
There were three.
There were three. Okay. We can then go to call up GWC 0002 0016 001 at page 337. So this is a paper which is identified as having the author of Acting Deputy Director Licensing, Nick Toyne,
Yes.
and its topic is to amend regulations reapproval of junket operators and representatives. Nick Toyne, you might be aware, has given evidence that says he says he didn't prepare this document, even though his name is the his name is the author, and that he hadn't seen the document before this Royal Commission commenced. Do you know, or are you aware of who wrote the paper?
It is my understanding that he authored that paper. He wrote that paper and drafted it. That was on the basis of examining the archival files where these reports and the original submission was in place. There's his writing on there that he had prepared the paper, which is 8.2.
And did anyone else have involvement other than
I would have,
Toyne?
in
in preparing this paper?
I don't know.
So what's the material that you're referring to, which you've referred to?
Well, that's why I said I want the belief that he did author that paper because there was a file or a number of files that were from archives where going back to 2010 and that original submission from Crown, I think it was one of the attachments, there was, I only saw it, but there was a notification from, I believe, Mick Connolly to Nick Toyne requesting him to prepare an agenda paper for the Commission, and the next handwritten note was from Nick to say that that had been done by him.
Do you still have a copy of that?
I don't have the copy, but the department has that original document.
Subsequent to this agenda paper going to the Commission, there was a repeal of the regulation under the casino control regulations in respect of a total repeal of the part of the regulations that dealt with junkets. Are you aware whether there was any requirement for the casino to notify the department or the Commission about junkets after 2010?
Not that I'm aware of, no.
And have you received any notification about junkets from the casino since 2010?
I can't say for certain that I have.
Or to put it another way, do you recall having received any notification about junkets from the casino?
I don't recall.
So, to the best of your knowledge, you have not received any notification about junkets from the casino?
I have not, to the best of my knowledge.
There's no further questions, Commissioner.
Thank you, Mr. Sharp. Mr. Damananda,
Nothing arising, thank you, Commissioners.
Mr. Sadler, Mr. Malone,
Nothing, thank you.
Commissioner Jenkins.
So just picking up on that last point, can I clarify it? Whilst since 2012, you've been involved in managing the inspectors at the casino.
Yeah, I can't remember if it was exactly 2012, but certainly from 14 to 15 onwards.
14 to
Yeah.
15. Okay, at that period.
Yeah.
If inspectors were being told who the names of people who were coming to the casino to participate in junkets, the names of junket operators, the name of junket representatives, the dates they were coming, any other details. If inspectors were being told that information, would you expect to be aware that they were being told that information?
It depends in what format they were being told. If they had received notification in writing of a junket arrival or any documentation in relation to a junket, which I think from memory, and again I wasn't involved in casino regulation specifically from a management perspective, that documentation was forwarded to the department.
Sorry, if it was given to the inspectors, would you expect to be aware that it existed?
I believe once that correspondence hit the department and was recorded and registered, it may well have been referred to the licensing department of the agency. Again, I can only speak from the period where I was managing all the industries that our instructions were quite clear in regards to we didn't have an audit program that was very specific to the junket operations, specific to the activities as such, the source of gaming revenue that was derived from it. We didn't have a role. It was very clearly set out to us that these were matters that were responsibility of federal law enforcement agencies or state or federal police.
So I want to ask you some further questions about that, but starting perhaps from the beginning. When did you find out that the junket regulations had been repealed?
I think not long after the Commission's resolution, from memory.
And when you again became involved in casino regulation in 2014-15,
yes.
Did that change in any way, in your view, affect the inspectorial role?
I didn't. I guess from my perspective at the time, the problems that I had was trying to juggle managing an inspectorate, a declining inspectorate in numbers, to try and meet all the various targets across all the wide-ranging industries that we have to regulate. So I took it upon that the decisions that had been made at commission level were decisions that I've accepted, and I managed the team in accordance with those directions that were given.
Am I inferring, and tell me if I'm wrong, that in fact the decision made life a bit easier for you because it was one less thing for inspectors to worry about?
Well, you could say that from an operational perspective, but would it sit well with us that we wouldn't have a role with it from our perspective, integrity-wise? No, I think if we weren't so stretched and if we could focus our activities on the casino, then that would give us more of an opportunity to look into such matters. But I guess it needs to be then considered about what the role is of those federal regulators and what our roles would be and what our powers would allow us to do. We needed to be very sure and very clear about what we can and can't do and what we would be looking at, and whether we were going into waters that might be out of our jurisdictional powers.
We've heard evidence that at some point inspectors stopped attending junket buy-ins and settlements.
Yes. Yes.
Do you know when that occurred?
I don't know.
After you became involved in 2014-15, were inspectors at that point attending junket buy-ins and settlements?
I don't believe so.
Before junkets were prohibited just recently, and from the time that you became re-involved in 2014-15 until then, was there any monitoring of the financing of junkets by inspectors?
I can't say for certain if there was. I think our focus was on, again, the gaming activities and the control and the recording of gaming revenue, not the source of where the gaming revenue came from.
And in that same period, was there any monitoring by the inspectors or the department more generally of who was participating in the junkets?
Prior to...
So we're talking from 2014-15 to the recent prohibition.
No, there wasn't, no.
Would inspectors, and I'll limit it to that same period of time, would inspectors in performing their audit and inspection programs ever see the casino's bank account statements?
Not necessarily, no.
Would they ever see a ledger recording how much money individual junket operators or international gamblers electronically deposited as front money?
They could. Our powers were quite ranging where we could, but I can't say whether they specifically did, but we certainly had the powers to examine all forms of documentation that in relation to casino gaming activity.
To your knowledge, did any of the audit or inspection programs require them to see that sort of material?
No.
And paragraph 38 of your statement, you refer to a specific part of the HIT operation audit program.
Yes.
Do you know who drafted that information and direction?
Yes.
Who did that?
All right. Which is what I explained to the regulatory services team. I spoke earlier about how from 2015, when the Commission adopted the strategic change, the regulatory services team, 3 officers were appointed to take charge of all our audit inspections, review, refresh, create new audit inspection programs. So they were the sort of the holders of that. That was their responsibility to create these programs. And as I said earlier, there was a lot of collaboration, but the drafting of that particular audit program was done by that regulatory services team.
And have you ever discussed that with the authors?
No. No. Not that I can recall.
Oh, I was only asking you that in case you had any idea where they had obtained that information from. That's all. But if you haven't spoken to them, then we'll leave it at that.
Yeah.
Can I follow on from that?
Yeah,
Finish
sure.
that? Just while you're on that subject, to your knowledge, or as best you can recollect, was this a new audit program that came into being because of that 2014-15 review, or was it a revision of an already existing one?
I think it was a revision and an enhancement of an existing program.
So as a result of that information and direction, did you ever speak to inspectors about what their approach was to material which they saw in the casino's finances that might sort of indicate some money laundering or suspicious transactions?
I don't recall having discussions with inspectors or inspectors approaching me about anything in relation to something they may have identified in the course of doing any forms of financial audits. If they did identify something, I'm sure they would have raised it with me.
But would it be correct to say that that as far as you managing the inspectors,
Yes.
as a result of that kind of information, you and other just as a result of that kind of information, was it your view that it was not the role of the inspectors to conduct their audit and inspection programs with an eye to detecting money laundering?
That's correct.
So is it correct to say, or fair to say, that certainly in that period, say 2014 onwards, that you did not consider that money laundering was, and the detection of money laundering was part of the Inspectorate's responsibility?
Well, that's because we were working under the directions that we received from above, which was endorsed by the Commission. The programs that we have in place were designed around, as I said earlier, around the integrity of casino gaming activities and the appropriate recording of revenue for taxation purposes. It was made clear that that was what our role was, and that the roles that the matters that you refer to in relation to AML or CTF activities was very clear that they were roles for other authorities at a federal Commonwealth level. So despite that, we did what we were instructed to do in the absence of anything better or any change.
So then I want to ask you about the period from 2014 when there were the occasional media reports about and allegations about international gamblers being involved and junket operators being involved in money laundering.
Mm-hmm.
Did that material before and prior to the publication of the Bergen report ever cause you to think that the Inspectorate should be doing more in this area?
Yes.
And if so, did you raise that with anybody within the department or the GWC?
I spoke to my directors. I have to preface by saying that since that period, and particularly since the departments merged under MOG, we've had 3 different directors under us, and in a fairly short period of time. So I found that having discussions with my director might mean to having repeated discussions with further directors about concerns. But those matters that were raised were prior to the Bergen inquiry, I believe were raised at a high level with the Commission. They were at higher levels. I may have had discussions with directors and inspectors about stuff where it might be of concern, but it was a clear direction and we followed that.
As someone involved in that period from 2014-15 in casino regulation here in Perth,
Mm-hmm.
and hearing those allegations, did you think that there was money laundering going on by international players at Perth Casino?
It was always possible that it could happen, so that was always a potential that could happen. But the controls in place by the casino licensee and the oversight by federal authorities was the instructions that we received that that was their responsibility to manage, whether that was Austrac or federal police or state police or even customs in who they allow into the country or immigration. So despite any concerns, that was clearly the direction that we operated under.
And prior to the publication of the Bergen report, was it ever suggested to you by anybody in the department that Austrac had concerns about the extent of money laundering in Australian casinos? I'm not saying in Perth Casino.
That wasn't raised to me. I certainly didn't come to my level of discussion.
And was it ever suggested to you that the border control authorities may have a gap in their monitoring of the situation?
It was never suggested to me.
I wanted to ask you some questions about foreign currency and electronic deposits of money for gambling. You were shown the, I think it was part of the casino manual, was it? Or that,
Yep.
that dealt with the redemption of foreign currency. So have you always known that the casino permitted gamblers to redeem their foreign currency?
It was in the manual, yes.
And similarly, what has been your understanding, and I'll preface it by saying prior to the publication of the Bergen report, just in case that's changed your understanding, as to whether the casino permitted gamblers to deposit money electronically, supposedly for gambling, but then redeem it at the casino for cash.
I didn't have a knowledge or an understanding of that or an involvement in that. So,
Did you think that the directions or the casino manual would have prohibited that?
possibly, but if it was in the, well, possibly.
Possibly or
Yeah.
possibly not.
Yeah,
You
or possibly not.
don't
Yeah.
know. And what about whether the casino permitted third parties to redeem money deposited as front money, as opposed to so if a gambler deposited money electronically, whether it was permitted for a third party, not the patron, but somebody authorised, supposedly authorised by the gambler, to front up to the casino and to either withdraw that money in cash or in chips. Was that permitted to your knowledge?
I can't say whether it was or wasn't.
Can I ask you about this Navigate system?
Yes.
So your evidence was that it does not permit departmental or GWC officers from independently verifying the casino's accounts. Is that right?
That's correct.
Was it introduced whilst you were involved in casino regulation?
Yes.
Do you know if the department or GWC had any objection to the fact that capacity no longer existed? Any concern?
I had concern, but that was a decision of the department at a corp executive level that system wasn't designed with the capabilities for us to independently calculate casino taxable revenue monthly.
And why did it concern you?
Because when I was a shift inspector in that period in my statement, you had an active role, particularly when you were a day shift, because every day you were dealing with the trading day of the day before, and that involved our direct involvement with attending the two counts, the hard counts, the soft counts, obtaining unaudited master game reports and various other reports relating to casino revenue chips. And once you perform those audits, you have that documentation there, source data, and you would then go up into our casino office, enter that data into our independent system for the trading day, and then you print various reports off to make sure that there were no variances or adjustments that were necessary. And then the night shift would come and then check your work to see if your entering of data or financial information was correct. So then come end of month, when we go to balance, the system was designed where it would actually calculate, because there's different tax rates. It's not just one tax rate for all forms of gaming. There's a different tax rate for gaming machines, for international, for Keno, for domestic table gaming. It tracks different tax rates. So the system was originally designed to do that once you'd enter all that data. So when you came to balance to do end of month, because the licensee must pay within 8 days of the end of the month, the casino tax, you could independently produce those reports, come up with a figure, and then you would confirm with income control at Crown to make sure that they balanced with what your figure was. So once you'd agreed on that balance, the next phase would obviously be that they'd make payment to the state government. So there was some autonomy, plus you always receive what we call the package, and that had fully audited master game reports. So we had primary source document and then audited master game reports and other reports that were provided by income control. So you could do some variation in checking across that. So obviously with the new system, that ceased. So we had to rely on our audit and inspection programs that we have in place now, which are audit inspections, particularly around casino tax. We're looking at various processes in place, particularly around the operations side of revenue, the role of the cage, the count room, income control, and other forms where revenue is collected. We would do our audits and inspections on those specific areas within Crown to make sure that they were doing their role in accordance with the procedures. And we also, and obviously I need to also preface that the ACMS, which is the Approved Casino Management Systems, the software systems, their IT systems, were always tested by an ATF, an accredited testing facility to make sure that the software systems that Crown utilise, and there are various systems, but it all forms part of ACMS, are approved to the standards by being independently tested and verified by an ATF. So the Commission can have some comfort over the fact that the systems that they use are accurate and they report taxable revenue and other records appropriately, and our audit and inspection programs that we use were sort of focused on the activities of the key employees that would use those systems to make sure that they are correctly using those systems appropriately to record taxable revenue. Hope that makes sense.
So you or the government is now reliant upon the ACMS systems as a whole, as you say, number of components to it, in order to, which, does it itself calculate the tax payable, or does the government get those, or the department get those figures and then calculate the tax?
Yeah, the ACMS is Crown's system, and obviously that's tested by ATFs annually, I believe. And obviously they use all those various systems that form part of ACS to record revenue. So when income control, which is Crown's division, they're the final collators of all that financial documentation and information through those systems. Then they use their system to then calculate what is to be paid at the end of the month. So that information is then fed through a portal that the department and Crown have, where they report through a portal. I'm not an IT expert, but that gets imported through this portal, and reports are printed off through that, and they're all based on master game reports and other financial documentation. Myself and inspectors, we would do a calculation to make sure that everything adds up appropriately and the casino accounting equations are adhered to.
Well, when you were doing it, you even attended the hard and soft
Correct.
accounts.
Correct.
So apart from the occasions when there might be an audit or inspection of those,
Yes.
the casino now would be doing those unsupervised?
That's correct. Well, we can and do have an audit program around attending count, but certainly not like it used to be. I mean, we were there, obviously, 365 days a year, so we would always attend those counts. So you had an independent process of, the count room would count and they would finish, and then the cage manager would be called from Crown that, hard count's ready or soft count's ready, and then the GI would be contacted, and then you go down. You have we had a program to follow, which we would do when we were in the count room, and we would get various documentation and reports, which I spoke of earlier, and you would do a count, not as in we'd start from scratch, but they were all bundled and strapped. So you would come up with a total, and the cage manager who came across, he would do a total, or she, and then we would check to make sure that we had the same amounts. If it was agreed, then that would be done and reports would be printed off, and off we went.
Can I move on to another topic now? And that is the question of infringements and offences. Now, you would be aware that it is an offence for the casino licensee to breach the directions,
Yes,
and it's part of the directions that the casino licensee also comply with the casino manual.
correct.
So consequently, it's an offence for the casino licensee to breach the casino manual requirements.
There's procedural errors and breaches of rules, but to breach the casino directions will be considered serious.
Can you recall an occasion on which the casino licensee has been prosecuted for breaching the directions?
I can't recall in my time of a prosecution.
then we might be getting close to the end of my questions, Mr.
It's okay.
Raddus, but, this is in relation to the granting of credit to international commission players. Are you aware that there's a Direction 3 capital F which permits the casino to grant credit facilities to international commission players?
Yes.
I'm a bit
Trying
unsure
to
about
think.
that because I wanted then to draw your attention
Could you?
to the compliance activity frequency model
Yes.
which you were shown, which says that there is an international commission business audit,
ICB. Yes.
and that refers to the funds advance facility, which is what I am talking about.
Yes.
And then there's also an audit of the funds advance facility.
FAF. That's
FAF.
right.
Now, first of all, if I can start with just the basic issue of, do you know why the casino is permitted to advance credit to international commission players?
I think because that seemed to be the nature of the beast globally for casinos to vie for, high rollers and big players to come to their casino. So that was part of business model where the risk was Crowns. If they were going to invoke FAF and allow credit to certain players, then they had a system of controls in place internally before they made those decisions to grant the program to individuals.
You've clearly got an inspection and audit program which
Yes.
audits those areas of the business. So you clearly think someone thought that it was appropriate that for the GWC to regulate
Yes.
that area.
Yes.
And just tell me that the extent of that sort of audit and regulation, did those programs in any way regulate the extent of credit that was being provided?
Not so much the extent of credit, but I think from memory, there's in the process of determining whether they were worthy of credit, the casino licensee had limits on how much they could provide. And that was the system of their own internal controls. I'm not 100%. I'd have to review the actual audit program itself to answer correctly, to be honest. But for us, our audit program wasn't drilled into perhaps looking at the levels of credit and why.
Or to who was being provided credit or...
Yeah, we make sure that they had done checks to ensure that they are who they are. So that's through passports and examining identification and where they came from, things like that.
And did it include any examination of the extent of bad debts arising from FAF?
Well, they would send, the casino licensee would send correspondence to, I can't remember if it was addressed to the chairman of the commission or the chief casino officer of their debts, their debtor reports, which would have an extensive list of who owes what.
And did you see those reports?
I've seen them, yes.
Do you know whether they were provided to the GWC?
I can't say if they have. I certainly can't say they've been recently. I don't know. I don't believe so. If I could just add, with that FAF program, the risk obviously is on the casino licensee to say, look, here, you're credit worthy, you're good for it. Crown still pay the casino tax on that revenue. whether they'd given it away or not. So the risk was on them to ensure that they were going to get that money back from their players. But they were always going to have to pay casino tax on whatever that revenue was.
Well, I hear what you're saying, Mr.
Yeah.
Bradley.
Yep.
If they're owed a certain amount of money, then it might impact on their ability to pay tax, mightn't it?
Correct.
So then it does become
Yep.
a regulatory issue.
Yes.
I think you were asked whether you had an audit program for socially responsible gambling or problem gambling.
We don't have one.
We don't. Have you ever considered having one?
It is worth considering, yes. We have in the regulatory services team staff that deal with responsible gambling or harm minimisation, so a responsible service, responsible gambling team. So, yeah, there's always scope for that. The Commission, at present, they're certainly looking at that focus on harm to the community. It's in the objects of the Gaming and Wagering Commission Act. Whilst, as I said in my statement, there's a balance between acquiescing to industry and growth, and that's fine, but it has to be balanced with the need to ensure that we can't cause too much harm to the community as a response to whether it's gambling, or responsible gambling, or responsible service of alcohol. It's a fine balance.
Can I ask you about the removal of the inspectors and asked you who instigated that? Whose idea was it?
I believe it was from the Deputy Director General.
Who was at the time?
Mick Connolly,
And
I believe.
do you know why?
Sorry, he was going to add something.
Yes, sorry.
I believe it was Mick Connolly.
Have you ever discussed with him why he wanted to do that?
I can't really recall getting an explanation as to why offhand. There probably was discussions, but that was the decision going forward, that this was a new change, this was a new direction, and obviously there'd been discussions at perhaps higher levels, and it obviously went to the Commission and it was implemented.
Your audit and inspection program, do you know how the Western Australian program compares to interstate programs?
I don't.
And a final subject area, conflict of interest. I want to ask you about Mr. Connolly's friendships with Claude Murray, John Nichols and Paul Hugh. Prior to the media publicity about these friendships, were you aware of them?
I wasn't aware of them to the extent that they are now. I wasn't. No. I was aware that there was some friendship, but I don't know the depth of it.
Not taking that as the position, do you think you should have been made aware?
Officially?
Yes.
Yes.
And in relation to the conflict of interest between the inspector's role and the having a child employed at the casino, and I want to know the details, but how senior is the child's level of employment?
He's not in a management or supervisory role, I believe.
Do you know whether in the course of their duties, that is the child's duties, they would interact with GWC or departmental officers?
Rarely.
Oh, hang on, one last question. What's the name of the inspector who trained you?
Vanessa Margaret Webb.
Very good. Just a couple. You've talked a lot about the audit programs developed by the Regulatory Services team.
Yes,
It's fair to say they're focused on revenue and the integrity of gaming.
that's correct.
And you talked about how they're improved based on feedback from the individual programs. Has there ever been a stepping back, doing a strategic review to see how they address, say, the manual or the directions?
Not yet.
Okay. They appear rigid to me in terms of your compliance table and the fact that you look at EGMs in January and July. Is there any element of randomness to, you know?
Well, yes, there is, but not as often as you might think. But again, look, I just try to make clear the complexities of trying to manage dwindling resources is very difficult, and changing priorities is quite a challenge, particularly when you're dealing with industries that are, have the propensity to
Well, that's
go really bad.
That's
so.
my last question.
Yeah.
Your understanding that the inspection process is funded indirectly through the casino licence fee?
Are they? Is that the question?
I asked you if it is your understanding, or do you understand how they are funded?
I don't understand how they're funded, no.
It's just that in the resources being applied have diminished, both in terms of the numbers and the percentage applied to the casino over time.
Yes, well, it's certainly diminished, yes.
And you're
Yeah.
not aware of why that is?
No,
I
don't.
Okay, thank
No.
you.
Yeah.
Mr. Radis, while that is the document still on your screen?
The frequency
Yeah.
model? Yes.
It's 2017, but in terms of the left-hand column, which describes the audit and inspection programs, is that still reasonably current?
Yes.
And this follows on from a question that Commissioner Murphy just asked you, but this came into your statement through paragraph 39 of your statement. Do you have your statement there? Can you have a look at paragraph 36?
36?
36. Now, when I read that, is it really related to the matters that are set out in paragraph 36 of your statement?
That's correct.
Okay. So can I put it this way, they're really operational matters rather than matters of higher strategy?
I'd agree with that.
All right, thank you. Just on that, there's another acronym in that. ICB, I understand. FAF, I understand. There's another one, CCF. What's CCF? It's in the column for both international business and the...
Check cashing facility?
Excellent. Now, in an exchange with Mr. Sharp, we went to the ideal world. If you did have additional resources, how they would be utilised. And one of the things that you mentioned was forensic audit. What were the areas that you had in mind if you were able to engage forensic auditors? What are the areas that you would have them look at?
Well, bank accounts and international transfers of fees, of funds, I should say. I do have faith in the inspector's skills set that they can calculate casino tax. They do have that ability to do that, but that, as you said earlier, is more operationally based. But that forensic type audit, you can drill a bit further down into the transfer of funds, particularly electronically, as well as through the cage. Or more focus on that.
Thank you. Now, do you remember Mr. Sharp asked you about Section 2 of the casino manual operations, which is to do with cage operations, and he took you to item 1.5, which says that the casino licensee must maintain an AML program. Do you remember that?
Yes.
Now, you said, well, in the past we've never audited that, but we're putting that in place.
We are currently looking at how we can draft a program, or whether audit or inspection program, around what's in the manual. So that's in development,
Well,
in early stages of development.
up
But we haven't sort of drilled down to exactly how, because I think we need to be sure about what our powers are, what we can do, and specifically what we should or shouldn't be looking at. And that might mean collaboration with federal law enforcement agencies that deal with that, or AUSTRAC. So I think there still needs to be a little bit of work around how we're going to do that. But if we're looking at the procedures, simply an inspection program to say, are you meeting your obligations to report, transactions? Yes, well, show us how you do that. Now, the specifics of those individual transactions that they're reporting, maybe that would be something that we can't look at. I don't know, because of we might be stepping outside of our powers, our legislative powers. We haven't explored that just yet.
yes, because it occurs when you think of the purpose of audit generally. Step back and just look at audit generally. It's to pick up irregular transactions on the one hand, but it's also to detect systemic error.
Yes.
And if there are two things about systemic error in relation to that item 1.5. One, whether there's a manual at all.
Mm-hmm.
And secondly, whether, if there is a manual, whether it's fit for purpose, whether it's actually achieving its role.
Yes.
Now, would you see a role for the inspection and audit team in detecting systemic error within the process that's required by the casino operating manual, as opposed to actually delving down, digging down to detect individual instances of criminality?
Yes.
And is that something that you have in mind in terms of developing this new program?
Yes.
And might that, if it comes to the fore, require a rewording of the quote from the pit operations manual that's set out in paragraph 38 of your statement?
It could possibly, yes.
All right, thank you. Anything arising from any of that, Mr. Sharp?
Only one question, which is just that in response to the questions from Commissioner Jenkins, you identified that there were 3 regulatory team members.
Yes.
And are you able to name who those were, who would have developed?
Yes. Sandy Del Preti was the leader of that 3. He has extensive knowledge and history, background in casino regulation. Aileen Watt, who has now left the department, she's retired. She was an ex-casino inspector with very good experience. And the 3rd person is Kelly Pemberton, who's still in the department.
No further questions.
And the last say goes to Ms. Seaward.
People will be relieved to hear I have no questions.
Me.
Mr. Radders, thank you very much for your evidence. It has helped us.
Thank you.
And you've fulfilled your obligations under the witness summons and you're released from those obligations. We will now adjourn to a date to be fixed. That concludes this session of the evidentiary hearings in relation to what's called Part B, but it is not the conclusion of the evidentiary sessions on that. We will have to return at a later date. We will publish on the website a statement in the near future about progress and about the conduct of future hearings, but for the moment we adjourn to a date to be fixed. Thank you very much.